on live.
Thank you. Recognizing a quorum of commissioners, I call the December 4th, 2025 meeting of the Cannabis Control Commission to order. This meeting is being held hybrid pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Benedon, Stebbins, Ray, and myself participating in today's meeting. Although today will be by roll call. We have a full agenda today that I will generally summarize. We will start with opening comments from commissioners before we proceed to commission discussion and votes. There are 3 items in the commission discussion and vote section today: red tape removal committee structure and roster finalization, secret shopper program and debarment update, and discussion and review of draft regulations and policy questions, revisions to 935 CMR 500 and 935 CMR 501 regarding social consumption. I will ask that commissioners wishing to comment or ask questions during any part of the meeting, please raise their hand to be recognized. With those initial comments, I will turn things over to commissioners for any comments or updates, and we will start to my right with Commissioner Roy.
I wasn't ready for that.
Okay, sorry.
Good morning, Madam Chair, and good morning, my colleagues and everyone. I will be really brief. I just want to thank Solar Cannabis in Somerset, Mass, my hometown, and David O'Brien and the Cannabis Business Association for hosting myself and the chair. Recently, we went down to Somerset on a beautiful day, and there was about 60 folks that attended, numerous licensees from across the state. We had a very informative and lively discussion and some great Q&A, which segues me to the agenda today. What came up during our roundtable was the red tape removal committee, and folks are super excited about it. I am too, being one of the co-sponsors with the chair. We're going to talk more about that today. There's already some great ideas on how we can have significant wins for the industry while at the same time not sacrificing public health and public safety. And also, I'm super excited. We are nearing the finish line and honoring the will of the voters around social consumption license type. So we're getting real close and excited to put a bow on that for the holidays. So
you're not gonna make an appropriate family brag, if you will, about your visit to Solar.
Oh, no, would you like to do it for me?
I'd like you to do it.
Okay.
Because it's very interesting.
Okay. And I've told many people, but I grew up in Somerset and South Coast, and the Braga Bridge, for those who have visited down there, spans the Taunton River between Fall River and Somerset. And that was dedicated, the Braga Bridge. That's my great uncle, Charles Braga, who perished in the USS Pennsylvania in Pearl Harbor. So I have many photos of my mom and my grandmother and my aunts and my great aunts with Governor Volpe at the time and State Senator Mary Fonseca dedicating the bridge to my uncle Charles Braga, so my great uncle. So
what's the connection with Solar?
Oh, and Solar, that's right. So Solar, it came up because Chair was telling them about it, and he said, I painted our building Braga Bridge blue. So it's painted Braga Bridge blue. I said, well, that's my great uncle. So
I thought that was probably
that's a kind of cool little factoid. Braga Bridge blue. I didn't even know that's a color now. Braga Bridge blue.
Well, now we know.
So thank you, Chair. I appreciate that.
Thank you, Commissioner. Commissioner Stebbins.
Thank you, Chair. Now I've got to ask Benjamin more about Braga blue.
Braga Bridge
See if they have that color. Just a couple of quick updates. I want to thank T-Bear and Alternative Compassion for hosting me for tours just before Thanksgiving. Chance to meet with their many team members. T-Bear in Wareham makes Coast edibles and infused chocolates. They also shared with me they have a child-proof chocolate container made from recycled plastics collected from the ocean. So that was kind of neat. Alternative in Bridgewater operates in both the medical and adult use license space. So had a good discussion, including changes for our medical licensees and discussion about the heavy license renewal fee for our medical licensees. I might steal a little bit of Commissioner Benedon's thunder, but she and I also had the chance to tour Low Key 2 prior to them opening their doors in West Roxbury, and also had the chance to meet with Phil from Freshly Baked, another equity licensee from Taunton who's supporting the new owners. Also enjoyed the chance to listen into one of the in-person equity program trainings last night, thanks to Darius and Stephen, who are on the call and answer questions in the chat that pop up from our attendees. So that's it.
Thank you, Commissioner Benedon.
Yes, thank you, Chair. I want to start out by thanking all of the commissioners as well as staff who have made my transition and onboarding go so smoothly. I feel like I've learned an incredible amount, really the entire team, starting with the HR team, the IT team to get everything set up, as well as the other departments within the agency, legal, enforcement, licensing. Really, everybody has just gone out of their way to get me up to speed, to share everything that they've been working on over the last several months so that I can come to these meetings and be informed. So I'm really grateful. I'm seeing what terrific staff there is here and realizing how lucky we are to be supported by such a phenomenal team. I will mention, as Commissioner Stebbins alluded to, I did join him for a visit to Low Key, the retail establishment that we approved a license for at my very first meeting on November 18th. And so it was terrific to approve that license and then to be able to go talk to the entrepreneurs behind that establishment, hear from them both about their challenges as well as their successes, and meeting with the proprietors, the entrepreneurs that really are the backbone of this industry. I think is something that will be a priority for me as it informs how we go about doing our work as commissioners.
Thank you. And I just also want to add my ongoing thanks to the IT team because they know I am technologically challenged and they are constantly helping me figure things out. So I want to give a special shout out to Paul and the team. I also want to, one of the things that I did want us to note is that when we visited Solar in Somerset, one of the things that they are doing, which is really interesting, is they literally are, I believe, a registered power plant. They are doing everything sort of, internal, very, I don't know if they're completely energy independent, but are moving in that direction. And one of the conversations that we had on the way out is we actually have an opportunity to recognize certain licensees for doing different things that we think are promoting a good behavior in the industry. So I think it's something we should consider taking a look at in the future, seeing what some of those licensees are who are doing some good things in the community that we should recognize. So anyway, I did want to recognize that they're doing that. It is obviously, some people may or may not know, but one of the most significant drivers of energy consumption increases in Massachusetts actually has been the cultivation of cannabis. So whatever we can do to reduce energy use is usually a good thing. So anyway, I just wanted to comment on that, compliment them, but I do think that we might want to think about that in the future. And so turning to that, we are not today having a report from the executive director unless the executive director would like to make some comments right now. Any comments or updates that you have for us?
No, thank you, Madam Chair.
There you go. All right. That was easy. All right. So we're moving right now to, Commissioner Roy.
May I have a piggyback comment on yours? So I agree with you. We did talk about that in 500-040. We have a leadership rating program for marijuana establishments and marijuana related businesses with the categories social justice, local employment leader, energy and environmental leader, and compliance leader. And I'm requesting for a future agenda, we put this on and figure out the process on how we get to recognize folks. So I just would like to say, if you could put that respectfully request.
Thank you.
On a future agenda.
Well, we will have a chance to do that. Thank you very much.
Thank you.
So moving now to the red tape removal committee structure and roster finalization. And I want to thank Commissioner Benedon for also weighing in on us thinking about this, and Executive Director Ahern. So we will be putting together, and Executive Director Ahern has helped us put together a charter and a motion for this. But what we are trying to do, the conversations that we've been having with a number of different licensees, is how do we help the businesses that are struggling? We know that anywhere from 25 to 30 businesses are looking at or have already surrendered their licenses this year. And how can we as a commission help them with the increase in cost, help them become more profitable, help them become better contributors to the important work that the cannabis industry supports in state government. Commissioner Roy has really led the way on this. I congratulate her on that. So we're putting together this roster, and I want to, I'm just saying, do I have the motion for that?
I can put it in the chat,
Yeah.
obviously, pretty high level, so.
But Commissioner Roy, do you want to make any comments just quickly about your thoughts? Because this has really been something that you've led the way on.
Thank you. And, obviously we've done a lot of work collaboratively with Chapter 180 and HCAs and municipal equity and pivoting to social consumption. But, as we move forward and we realize that some of the regulations that were in place made sense at the time, maybe no longer make sense, or, their utility has expired and maybe we can sunset some of these things or modify or adjust and, and create some wins for the industry and the agency, but not sacrifice public health or public safety at the same time. And so people are super excited about this, as you saw, Chair, at the roundtable in Somerset. So today, I think we're just going to announce who the folks that we've identified for the group, talk about how the structure based on the motion language, if it's more of an informal or formal structure, and, report back. And I think we need to add that to the motion language by June 30th. If we could just add, I was just going to send that to you, and bring some great recommendations on, maybe it's RVT. We all agree, right? No disrespect to our RVT trainers, but it's a little stale, and how can we look at that? And, I know Commissioner Stebbins, you worked on agent badging, and, I said architectural reviews, maybe that's something that we can sunset, that makes sense. So I'm really excited and, really ambitious on this and, want to hit the ground running. So thank you, Chair.
Great. Commissioner Stebbins.
Thank you, Chair. And thank you, Commissioner Roy. I think since all of us have started working on the commission, we've heard these, like, this bothers me, this isn't working, this is too much. I certainly, and I've shared this, I think in a public meeting, certainly with licensees that I've talked to. I think our inaugural commissioners gave us, some have called it conservative, some have called it almost prohibitionist, but a conservative set of regs. Cautious, great word. But I think that has given us the opportunity to look at things and begin to peel things back. Had they been too liberal or too lax at the beginning, we'd be constantly adding stuff, and that doesn't, offer confidence to the marketplace. I would suggest, and appreciate the work that both you, Chair, and Commissioner Roy are about to undertake. Some of it is also not just looking at, where can we relieve some costs, where can we relieve some regulatory burden, but also be mindful of where we can offer clarity in our regs. We always hear, I asked, our I&E team, and our I&E team is not there to necessarily always give you guidance, and the response is, go talk to your lawyer. So look for those places that we can also offer clarity so that I&E team knows what to expect and our licensees know what to expect. But that isn't necessarily a cost savings, more as maybe a headache savings. But yeah, I appreciate the work ahead and look forward to seeing what we can come back with.
Great. Thank you. So we do have motion language that is in the chat here. So I'm just trying to think about how. So what I will do is I will announce, and some people may be surprised, some people may not be able to do this, but these were some folks that we had who had either self-identified or who we had identified on the external side who could be helpful to us. But I will note that from the previous motion, and we will be moving to amend the previous motion. So from the previous motion, the internal staff that'll be working with Commissioner Ryan and myself will be Jake Nielsen, Erica Bruno, Dara Sands, Jessica Porter, Andrew Carter, and Paul Clark. So those people are already from that previous motion. And then we had representatives from different organizations, Kevin Gilnack from EON, David O'Brien from MCBA, and Ryan Dominguez from MCC. And we had gotten recommendations from some of those folks. So these are some of the individuals that we will invite to work with us on this informal group. And I will also read, and again, I thank Commissioner Benedon and I thank Executive Director Hearn for helping us figure out how we can do this in a way that is consistent with open meeting law, but also allows us the most flexibility to get the most information and move as quickly as possible. And some people may have to decline this request to work with us, but from the labs, we have Megan Dobro from Safetiva, Chris Hudala from ProVerdi Labs, Retail, Meg Sanders from Cannon Provisions, Caroline Frankel from Caroline's Cannabis, Nike John from the Heritage Club, Victor Chang from Ready, Amari White from Firehouse Cannabis. From manufacturing, we have Angela Brown, Coast Cannabis, Kristen Rogers from Levia, Brian Adams from Hudson Botanical Processing, Indoor Cultivation, John Napoli, Vanguard, Dominic Shelsey from Wellman Farm, Outdoor Cultivation, Cheryl McGuire from Stafford Green, Matt Allen from Sungrown Cannabis Alliance, John Pasecki from Wiseacre Farm, and then verticals, we have Ed Dow from Solar Therapeutics, David Noble from In Good Health, Jennifer Keeley from Salisbury Cultivation and Production, Rob DeFazio from CNA Stores, and finally delivery, Chris Fevry, Your Green Package, Devin Alexander, Rolling Relief, Alyssa Nowak, Lucky Green Ladies, Ulysses Youngblood, Major Bloom. So in case anybody says, oh my God, what are you getting me into? We're not getting you into anything. We are asking you if you would work with us on this informal group that will be making recommendations to the full commission. And so I'm just going to walk through the processes, because this was something, and we can give this to you, but again, I thank you, Commissioner Pendon, for providing us with some background and information. So the informal working group with external consulting, and this is going to be a working group that will review regulatory work. It will review with external consulting team, the external folks we just mentioned. We will prioritize recommendation of changes to regulations and associated policies, and then make recommendations to the executive director, who will then bring this to the commissioners. We have it no later than June 30th, 2026, but we would like to move more quickly on this. But that gives us a hard stop that we need to get this done by. Meetings are not required to be noticed by open meeting law. Decisions on use of hybrid are not needed to reach quorum, but we will be doing these as hybrid to ensure accessibility. And scope, we will have regulations and associated policies. Out of scope is anything other than regulations and associated policies. And so again, the external stakeholders, the consulting team will be reviewing and providing feedback on what the external stakeholders give to us. It'll go to the executive director, and then the executive director will make recommendations to us. And we'll share with you, now that we have regularized this in open meeting. So anyway, with that, Commissioner Roy, and let's see, Executive Director Hearn, you put something in the chat. Do you want to?
Thank you, Madam Chair. I do have a motion, and we can discuss that. And if anybody needs edits to it or feels it's not fully vetted, we can discuss that. And then I also put the original motion from the October 15th meeting. That motion would have set up probably more of a formal group. I think this decision gives us a little bit more flexibility. We can do all of the things for accessibility under this structure. So I would just rescind the original motion and look for this one. But again, if there's anything in the suggested motion I provided that people need clarity on, happy to edit. And then I just provided the original motion for reference.
So I'm just trying to make sure, and I do not have my Robert's Rules for Dummy book with me, which I usually have, but I don't have it right here today. So I'm just, I might want the general counsel to advise us on Robert's Rules of Order about whether or not it says here we would move to amend, but do we have to are we just amending the previous motion? Because I'm not clear on how we should function in terms of Robert's Rules.
Thank you, Madam Chair. As we have members of General Counsel here, and I can't see behind me, but happy to have that conversation. I think ultimately I would personally be comfortable with amending or rescinding with a new motion. I think either way, we're accomplishing clarity on how the group is being established, and that's, I think, what we're just trying to do.
Okay, but that's so.
As it's written here, I'd be
we can move to amend the previous motion. The general counsel is standing up. Maybe he can join us and provide us with some information.
Good morning, Commissioners. Thank you, Madam Chair. In terms of process with respect to this motion, I would suggest that you all vote to amend the the prior motion. And then you can move forward with a new motion and then vote on that new motion. So that would be the steps I'd recommend here.
Wait a minute, would we amend or rescind?
Well, you can do either. So the first step would be to take a vote to either amend or rescind, and then you would consider the new language afresh.
Okay, all right, thank you. All right, so how about this? Commissioner Roy, I will entertain a motion to amend the previous motion on red tape removal and finalize the roster invitation of external invitees as stated to work with the red tape removal working group to review recommendations for prioritization of future regulatory changes for commissioners to consider no later than June 30th, 2026.
So moved. The only question I have
Yeah.
is, should we just put the date we voted on the original motion in this motion, even though we throwing it out there?
Madam Chair, I'll
Please, thank you.
just add to this, that the original motion was previous motion on red tape removal from October 15th. Is that right?
Yeah.
Yep.
Supreme clarity.
Absolutely. It's in there now.
Okay.
All right.
Do you want to reread it?
Okay, move to amend the previous motion on red tape removal taken on October 15th, 2025 and finalize the roster invitation of external invitees as has been presented by the chair to work with the red tape removal working group to review recommendations for prioritization of future regulatory changes for commissioners to consider no later than June 30th, 2026. Do I hear a motion, Commissioner Wright?
So moved.
Do I hear a second, Commissioner Benedon?
Second.
Having been moved and seconded, I will take a call the roll. Chair votes aye. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
It is passed unanimously. Thank you.
Okay.
Okay. All right.
Madam Chair, I believe people will want that list of roster invitees, so I will provide that to Collins. if that's all right.
Please, thank you.
Great.
Okay, so we're moving now. We have secret shopper program and debarment here in the same area of discussion. Commissioner Roy, this is something that you have been sponsoring, and I'm just trying to say, we don't have a vote here. I think we're just sort of talking and sharing with people what we are doing right now, and also just sort of discussing the issue. And some of this, and this is also one of the things, again, because we do have a new commissioner and because we do have the limitations of open meeting law, just making sure that we're all in the same room so we can understand, what is going on with this process. So yesterday we did have a presentation from a couple of the groups looking at testing. We know that's an important issue. We have this ongoing group looking at secret shopper. So and this is also really important because several years ago, I literally raised the question about whether or not we have a secret shopper program, and it was implied by senior staff that we do, but we don't. We do not have a secret shopper program. We have an intermittent process whereby we do go and we can do confirmatory testing, but because it is a problem that we do not have an independent standards testing lab, it makes it somewhat difficult for us. We actually, Commissioner Roy brought to the table about a year and a half ago, 2 years ago, working with, I think it was John Carmichael, who was then the chief of police in Newton. They had some money from ARPA or something from COVID, but that was not seen as something we could move forward with. So we're now looking at some different ways that we can create and fund a secret shopper program that allows us as a commission to make sure that we have products that are properly labeled, that protect public health and safety, and that protect consumers in terms of their purchasing
what they think they are getting in terms of THC levels and other things like that. So Commissioner Roy, do you want to talk a little bit about what you have, been working on this?
On secret shop.
Please, thank you.
Yeah, so I'm happy to be back on the working group. Thank you, Chair, on Secret Shopper. This is something I brought up a few years back on an agenda. I don't know if you remember Commissioner Stebbins and Chair, and we had a conversation, and there was clear. We all had a different understanding of what was occurring around Secret Shopper. It's in regulations. It's on paper, and before we would be, we were loath to talk about it, but no. We need to talk about it. We need to make this a real, robust reality. And I know the team has been working. I want to thank Chief Jones and the team. They've been working creatively. Like I've said this publicly. I spoke at Holy Cross last year, and I was asked about Secret Shopper, and I said, it sounds easy, right? Buy the weed, test the weed. Well, it's not that easy. Who buys the weed? Who pays for the weed? How is it safely transported? It is evidence at that point. And then without a standards lab, it makes it tricky. And with our current budget constraints, it makes it even trickier. But we are executing confirmatory testing. So that is happening. So I don't want folks listening to think it's not happening right now. It is happening. We get leads, we get tips. Commissioners don't. It goes to I&E, and then they follow up if they're credible and follow up on it. And part of that is confirmatory testing that is occurring. And so what we want to do is take it to the next level, and some of it is resource dependent. I floated an idea recently, and that's what we're doing. We're looking at creative ideas and solutions, and not how can't we do it, but how can we do it. So I want to thank you, Chair. I know you've had a renewed focus. We do need to get resources to be able to execute this, on a consistent and robust and random cadence. But anyway, I thank you for your commitment to this, and I think it's critical. It's been sitting in our regulations, living and breathing, and now we have to make it more of a reality. Thank you.
So again, this is a working group that we will be looking to put in place whatever changes we need to make this happen. Some of this can be done right now with the resources we have, but there may be some regulatory changes that will be needed and certainly funding is important. I don't know if Commissioner Stebbins or Benedon have any thoughts on this issue. Any questions, any thoughts, Commissioner Stebbins?
Thank you. And thank you, Commissioner Roy, for bringing this issue back. It is important, obviously. Appreciate the proviso that we still are executing confirmatory testing. And part of this is making sure that product being sold are what they say they are. There's also an element of making sure that our licensees are not selling to underage youth. Hopefully, again, as our industry expands, as we're now well over 300 retailers across the state, hopefully we can make the right argument that we need the resources to hopefully bring this to the execution stage.
Thank you. And I don't know if you have any questions, Commissioner Benedon, but this is a working group, and we've sort of re-energized it. So this will be something that'll continue to move. Commissioner Roy?
Yeah, and thank you, Commissioner Stebbins. And that is an important element as well. So it serves a twofold purpose, right? To do secret shopper, to do off-the-shelf testing, to confirm what's on the label is actually what's in the product, whether it's potency and it's total yeast and mold or whatever it is. We want to make sure there's accuracy in labeling, but also the like the ABCC does. Checking for age verification. And we're entering the new dawn of on-site consumption, which brings, another additional responsibility to the commission. And so the language, I don't, aside from resources, which is a significant challenge, I think we can easily address this in regulation when we do exclusivity, and I'm requesting it be in scope I try to get it in scope for this round, but we couldn't do it. So I'm requesting now before we even have a scope for exclusivity, because I think there's just some language under commission delegee and DGC. We've had this conversation where we can leave the commission delegee part alone. In secret shopper, we just need to give ourselves the flexibility. How do we send in young people if we can't partner with young people like the ABCC does in the local level, because the way it's written now, it boxes us in. And we can only partner with our other government agencies. That's how it was explained to me. So we need to have partners outside of that to be able to execute on the age verification, to execute, you know, on maybe it's someone we contract with, right, to do secret shop. We don't know what that looks like, but right now we're so boxed in under that definition. So we just need to give ourselves, the I&E, some flexibility to be able to explore different options. So it's not a hard fix. We can do this when we do exclusivity.
Yeah, I mean, the ABCC does this, and again, I used to be chair of the Lottery Commission, and the Lottery Commission, you know, does that as well. And they have teenagers that they, you know, they go in, and if you don't get ID'd to, you know, to sell a ticket, and it's a teenager, you know, they can get, you know, they can get dinged for that. So, Attorney Baker, can you just share, and just again, just making sure that we all understand, because I think that this is important, that, you know, it would be good to put this into the scope of the exclusivity. I think that, you know, it allows us a little bit more latitude to make some of those changes and to do it more quickly. So maybe you can just share a little bit about what that might look like.
Thank you, Madam Chair. Yes, this has been an ongoing conversation between Commissioner Roy, I&E, and legal, and ultimately there is a definition of commission delegee, which is reflected throughout the regulations. The specific section that Commissioner Roy is referring to is the section on secret shopper program. And because of the definition, how it's written and how it's tied in through all the regs throughout the document, I think Commissioner Roy is looking to create a carve out within that one section to have commission delegee mean something other than what it's currently defined as. So if the commissioners decide to deliver exclusivity and have a regulatory round with that, whatever you submit to the secretary as far as amendment goes up front, then that would be within scope. So I would advocate for you to do that up front, so that it is within the scope, and I don't have to tell you several times throughout the round that it's outside of it.
Exactly.
Commissioner Roy?
And so I think, Chair, if, again, this is on, you know, just tangential to this conversation, is maybe we have a scope, put scope on an agenda where all of us can say what we'd like to see in that scope. That way we're all on the same page. We're not, DGC is like, Commissioner Roy is not in scope, you know, like, you know, because I'm trying to get it in there for secret shoppers. So maybe if we put a scope conversation on, then we can all pitch in what we want into that scope.
Okay. We could do that in January, or would we need to do that sooner, because exclusivity is a vote that has a time frame. So please, thank you.
Thanks, Madam Chair. Yes, I think especially staff would appreciate that as well, so that we can prepare for what to expect in that round. Yes, I've spoken with the ED. I think the anticipated vote for deliver exclusivity would take place in January, so trying to tie those together would be very helpful.
Does that help in terms of timing?
Yeah, I guess I'm
Commissioner.
So we're going to vote on exclusivity, or we're going to get the Donahue report, the presentation from the Donahue team. We're going to deliberate if we might want to make changes to the record. Like, so we're going to have time to, and then does not have to go out to public comment. So, okay. So when do we have to figure out our scope list? You're saying January, but we're going to vote on it there? I guess I'm confused.
Madam Chair.
Yeah, please, if you could just give us, just so, again, so we know and we're not giving you anything at the last minute.
Yes, thank you. And I'm sorry for going back on some conversations we've had a public meeting before, but ultimately there is the delivery exclusivity period is going to last until April 1st of 2026. So that is essentially your bookend to make amendments to that exclusivity program. If you're looking to tie other regulatory changes to that timeline, then you would want to try to start that as soon as possible. And so I would advocate to you to try to have that conversation early in January, so that you're not holding up the deliver exclusivity timeline.
Commissioner Roy?
The April 1st expiration, DGC, do we have to have it promulgated by April 1 or just voted on by April 1?
The current regulations would say that general applicants can apply as of April 1st of 26. So if the board does not act before then to make amendments, then general applicants would start applying on the 1st.
But has he,
So do we have to be promulgated in the books or do we have to just be voted on
So yes, in saying that, they would need to be amended and finalized before April
and
1st.
filed with the Secretary of State prior? Okay,
Exactly. And
okay.
and Madam Chair, if I may.
yes,
that's
please, thank you.
why it's important to expedite this additional policy discussion in light of
Sooner.
this ongoing train that's leaving.
Thank you.
Executive Director?
Thank you, Madam Chair. And I'll just caveat everything that, obviously all of these agendas are at the discretion of the chair. So one of the things that we have lined up, to Commissioner Roy's point, is the UMass Donahue report with the exclusivity working group is intended to be coming to the commissioners within this month. And that, to your point, it is no obligation of the commissioners to make a vote in January. Everything that's being lined up is based on the idea of, should you have the report, should you make a decision that we then need to promulgate by that April 1st date. I think there are other things that we can discuss. Certainly you have had a high level discussion and not yet on an agenda, but I know that that is in the chair's consideration for the future of potentially licensing freezes, those types of things. There may be other mechanisms we can use depending on where the commissioners are, if they need more time when you're discussing the exclusivity report. As of right now, the intent is to get you the report. And then from there, the discussion deliberation is at the discretion of the board through the chair.
Okay, Attorney Baker?
Thanks. Just one more clarifying point that I wanted to make. If the board receives the report and decides, you know what, we want to let this expire, then no action relative to regulations needs to be taken. But obviously you want to have that decision in front of you and, done before April 1st and finalized. So just wanted to put that out there.
Commissioner Ray?
Yeah, and thank you for that. Thank you, ED. And also, we have exclusivity, but we're moving full steam ahead as a board because we have testing on the heels of that. So testing is going to be ready to go. That's the regs open again. So if we want to do a licensing freeze or whatever, or that discuss, so we're, the Celis train is leaving the station fast to get all of these things accomplished. So.
Yeah, but it's also just making sure that we do understand all these deadlines. And again, as Attorney Baker pointed out, we may or may not vote. We have to see the report. We have to see this was independent. There's no prejudgment here. And we did have an initial conversation. I don't know if everyone had an opportunity to speak to. Okay, so the Donahue Institute will be providing us with the work that they did. And again, I would like to acknowledge the work of the Donahue Institute and all they've done to help us meet our obligations. So are there any other questions or comments about this? But it's good to understand, and we'll make sure that everyone understands what the hard deadlines are so that we don't drive other people crazy, but also we do know that there is one particular deadline that if we want to move that into that framework to move things more quickly, we do need to work quickly on that. So is there anything else anybody wants to ask or Commissioner Wright?
Did you want to touch on debate?
Yes, I am. Yeah.
Okay.
Okay. So the issue of debarment was raised a while ago by Commissioner Roy, and I thank Attorney Ladzinski. I think he's out there, but I don't know if he can join us. But anyway, this is basically looking at what New York State regulators have done to, basically this is a pretty tough penalty that if you have seen, third parties, unlicensed third parties that have been collaborating with licensees for the unauthorized sale or diversion or inversion of cannabis products. It's my understanding that New York does not have as robust a seed to sale tracking as Massachusetts, but they do have greater enforcement actions related to unlicensed activities. And so I don't know if we could have, I don't know if Attorney Ladzinski is able to share. Commissioner Wright?
If he's not, I have just a little synopsis I can share.
If you want to do that, yeah, because I have this memo, which I think everyone has everyone received this memo in time?
Yeah. So
there's nothing we're voting on today.
no, this is, yeah.
But it's just, it's an issue. Commissioner Roy and I are going to be doing a meeting within the next week or two, looking at the issue of inversion, trying to understand Gail, is it a problem? Is it something that we need to be addressing more quickly? So, and a more robust conversation may be better entertained after we have that meeting where we understand maybe the true depth of the problem. But maybe you can explain why you raised this in the first place.
And thank you, Madam Chair. So it caught my eye. I was reading MJ Biz Daily, and there was an article, New York moves to punish marijuana distributor at heart of inversion scheme. So, reading the article, I saw this enforcement tool that I had never heard of before, and I asked for a legal opinion regarding it. And I do want to thank the legal team, and I wanted to thank, Attorney Ladizinski as well for doing this memo. But I just want to share for those listening a little background information. So it's not disbarment, it's debarment. So New York's cannabis debarment is an enforcement sanction that can bar a person or business from holding a cannabis license in the future and from contracting with, now this is in New York, with the Office of Cannabis Management or with licensees, usually following serious or repeated violations of cannabis law. Definition and legal basis. In New York's cannabis regulations, quote, debarment is defined as an exclusion from obtaining a cannabis license, registration, or permit under cannabis law, contracting or subcontracting with the OCM, contracting or subcontracting with licensees in the regulated cannabis market. Debarment is one of several penalties OCM may impose under Part 133 enforcement alongside fines, suspension, and revocation of existing licenses. When debarment can be imposed, debarment is generally sought in cases involving serious non-compliance, such as operating or facilitating unlicensed cannabis activities, including, quote, reverse licensing arrangements, where unlicensed businesses operate under another's license, material misrepresentations to OMC or failure to disclose significant ownership or operational changes, violations that undermine market integrity, public health, or equity objectives. Recent OCM charging documents and high-profile cases have explicitly requested debarment from applying for future licensure as a remedy, in addition to revocation and substantial civil penalties. Thank you.
So I think that the point and the reason that we'd like to explore this further, and again, it's really, I'm trying to regularize us having conversations because we can't have these conversations, and I don't think I don't think that the public can fully understand how cumbersome it is dealing within the open meeting law because we don't have the opportunity to have some of these conversations. But when I've been going out and having meetings, and I'm sure that all of you, when you go out or talking to the different groups, the operators who are operating under the law, who are burdened by significant taxation, burdened by significant, regulation, they want to do the right thing. And that's who I think we're getting the pressure from. It's the people who want to follow the law, who want to make sure that they're, paying their fees and paying their taxes and supporting the important programs that cannabis does support across the Commonwealth. So anyway, it's really understanding how do we as a commission strengthen the work of the good operators and making sure that the people who are not following the law don't have the opportunity to compete illegally or to undermine the health or safety of our system. So I don't know if I think that we probably should table this until we have a little bit more opportunity. But, I would suggest that we all take some time to read up on the issue of inversion or talking. We are going to be holding a meeting with a couple of people who have some thoughts about this. But I think that this would be something that we all should continue to educate ourselves on to understand. And some of this it is underground. We don't know it and we're trying to figure it out. We don't know whether it's real, but we've heard rumors that this could be a little bit more widespread than we think in Massachusetts. And so we just want to get ahead of it and we want to figure out ways to address it. So Commissioner Stebbins, you had a comment you wanted to make?
Thank you, Chair. And I think like Commissioner Roy and like you, Chair, I saw this article when it popped up in our news feed and really exploring the article, actually reading, I think there was a link to Green Standard Alliance New York. They had an article about it and where they were seeing it. certainly they were calling out the New York State's seed to sale tracking system, which they thought was lacking and was awaiting a long delayed implementation. But, you know, just thinking through the issue itself, not, I was thinking about it in two parts. If we were to uncover it happening, do we have the tools to stop it immediately from happening, either through, you know, our ability to cease and desist somebody, putting an administrative hold on product, and then the follow-up to that is how do we penalize the people that we catch doing it? So I ran through and jotted down a whole bunch of questions. I'll be happy to share those with legal and enforcement counsel, because some of it does tie back to other parts of our statute, other parts of mass statute in terms of what you can get arrested for, felony conviction for. But something that occurred to me last night, and then kind of picking up on our earlier conversation of some stuff we might want to add to the regulatory realm we know we may or may not have to do with exclusivity, is that we don't offer a definition of diversion or inversion in our regs.
We will now in
We
this,
will now.
in this round. Yeah,
Yeah.
they're now.
I mean, we speak to diversion, we do not speak to inversion, so we should try to find the places to couple those up, but we definitely need, let's start with the definition, and then we can think about, you know, the penalties later on. But
Yeah, and I think that's, so it's my understanding that we do need to make some regulatory changes before we can do this. In New York as a different legal infrastructure. But it's my understanding that way back when that this was left to the Attorney General's office. And I think it might not be a bad idea for us to have a meeting with representatives of the Attorney General's office to see what, if anything, some of this stuff would be civil penalties, and it's my understanding, having spoken with Attorney Lodazinski about this, that in New York State, this is actually a source of civil penalties and revenues that do come in. So obviously there's one issue when it comes to, I don't know, maybe a referral to the Attorney General's office for a criminal intervention, but this would be civil. So there are some ways that we could actually. So what do we do now? If we are aware of maybe a licensee engaged in an illegal grow or something like that, what do our investigators do?
Generally speaking.
Yeah, generally speaking.
I think, probably want to pull up I&E to go through the whole process. I think as it relates to kind of what we have now in the debarment conversation, and just to clarify too, this is not listed as confidential, so people will probably ask for the memo since we've mentioned it, so I'm going to provide that, so I'll mention that. I think the overlap of what we have right now with the debarment conversation that's kind of covered here in the memo is our suitability process, which is in our regulations. I think that suitability process allows us in certain instances people have anything in their background for it to be reviewed by the suitability committee and follow that process. But within our suitability process, debarment is not an outcome that exists and would require regulatory change. For just a general discussion on the process that I&E goes through in investigations, I believe the CIE is here if you'd like to get a high level summary.
Sure, yeah.
So, I think we may have to call her in. Let me just see if I can. CIA is on our way over.
Is she coming physically here? She's in the building. Okay.
If I may.
Please, Commissioner Wright.
Thank you, Commissioner Severson, you brought up inversion and diversion, which will be in this social consumption round once it's promulgated. So very happy to see that. Is inversion versus other gray market behaviors. Inversion is distinct from simple diversion of licensed product to the illicit market. Instead, it is the illicit to the licensed direction that corrupts the legal supply chain. It also differs from legacy or gray market storefronts that operate entirely outside of licensing, because inversion depends on at least one licensed entity willing to falsify records or structurally front for unlicensed operators.
Sorry, could you just, what are you reading from?
It was out of MJ, the source is Cannabis, MJ Biz Daily and Cannabis Business Times.
On the New York case?
This is just an overall, yeah.
Chief, sorry. We're generally raising, looking at New York State and looking at just discussing the issue of debarment. And we know that we would have to make some regulatory changes before, and possibly statutory changes. I'm not sure. I think it's just regulatory changes. But Chief Jones, what happens now? What is the process now when our investigators, if they were to find out about significant diversion of products or inversion, what do we do now? Do we refer it criminally? What do we do?
Thank you, Chair. Typically, the process is that we involve the police, would have to reach out to the police department, the local police. And then in some instances, we do reach out to the state troopers, to the state police through Mass Fusion Center to make a referral to them for follow-up.
And generally, how quickly do we do something like that? I mean, is it immediate? Like if we see something like that, do we refer it immediately?
Yes, typically we do refer, we make referrals as soon as possible, as soon as we're aware.
Commissioner Roy?
Do we make referrals to the district attorneys?
I have to check if we have. I do know for a fact that in an instance where it involved the feds, we in fact reached out, to the feds ourselves.
Okay.
Yes, to see, because we had concerns about jurisdiction and all that stuff. So we reached out to them to see what they were going to be able to do and make the referral. I'm aware of that. But in terms of the district attorney, I don't think since I've been at the commission, if we've ever done that. However, in instances where we made a referral to the police department or the state police, what they have done is, if the district attorney is involved, they've in fact reached out to us as well to let us know, of their process of what they're doing. And in some instances, they've requested that we participate as witnesses.
Is a criminal if we make a criminal referral, or if we go, is that confidential?
If we make a Chair, so if you're asking that if we make
I'm saying if we observe what we believe is potential criminal behavior and we make a referral, is that confidential?
Not that I'm aware of in terms of, in the sense of confidentiality. No, if we in fact made the referral and were asked to participate, we go through all the channels that we have to go, which is legal, to see if our staff have to participate and be responsive to what we're being asked to do.
Could we get a list of all criminal referrals that the commission has made over the course of the past 4 years?
Yes, we can do so. We'll look into it.
All right.
About that.
Thank you. I appreciate that. All right. I think we're good. I think that we can, I think Attorney Ladzinski is still having trouble getting in, but I think that we've kind of done what we can before we have some of these meetings on inversion. Thank you, Chief Jones. I appreciate it. Commissioner Roy?
Yeah, just thank you, Chair, and thank you, Chief Jones. Next steps, so we don't put this on the back burner. So we'll have an inversion meeting. Maybe you two, could have, because we can only do 2 at a time.
We could recommend, or you may know.
2 by 2. So whoever the 2 by 2s are, to have inversion meetings, and then figure out if it makes sense for us to tackle it in regulation once we've had get as much information as we can on it, and figure out if it makes sense for us to tackle it in regulation.
Okay.
Okay.
All right, I think that sounds good. Thank you, and sorry to,
Well, actually, may I ask one?
oh, Commissioner.
Do you have any thoughts on debarment? I won't put you, I'm sorry. That basically New York has this, it's not a hammer, and one could argue a sledgehammer, where if, so in New York, a massive inversion operation was discovered, and the Office of Cannabis Management levied an enforcement action of debarment, meaning those principals of those licenses can no longer in any capacity operate in the state of New York, even as a subcontractor with a licensee. So we don't have anything like that. We have suspension, revocation, fines, but we don't have that ultimate sledgehammer, if you will. So I just didn't know if you had any thoughts.
If I may, Chair.
Please, thank you.
Um,
And we don't want to put you on the spot.
Yeah,
I
if you
did-
don't have any
I
thoughts,
didn't
that's
sign you
okay
up
too.
for this,
Yeah,
but-
That's okay.
So, Commissioner Roy, I think, listening from the public meeting, as you indicated, that this would require some regulatory review and changes, and also for us to look at our current enforcement tools
Mhm.
to see how this would work. And then based on the article, from what I read, looking at what, the issue that happened in New York, as a matter of fact, I think our enforcement counsel might be available
Oh.
virtually. We've had an enforcement action in the past, back in 2021, I believe. I would have to look at the date. And the stipulated agreement is actually available publicly as well, where we had a situation with the licensee where they allowed, they basically assigned the duties of their license to another licensee. And so we in fact did look into that. So we've had an enforcement action related to something similar. Again, it goes back to regulatory amendments and also looking into the enforcement tools to see if it would align with what we currently have, or it could be similar to what we do with suitability. So I'm not so sure if our enforcement counsel is available to chime in as well.
Looking to see. Attorney Gooden, are you there?
Yes, Madam Chair, I'm here.
Voice of God, okay.
Voice of God.
All right, here you go. Thank you, Attorney Gooden.
Thank you, Madam Chair. And yes, apologies, I'm not there in person. I'm coming as the wonderful Wizard of Oz today. So just as we're kind of talking about the various enforcement options that are available to us, I just want to highlight for the board as well, just what's contained in our regulations currently as you're considering other options or things that might be available in other jurisdictions and how those might be transferable to the Massachusetts cannabis market. So as we're just kind of looking at the options as it stands right now in Massachusetts pursuant to our regulations, kind of our general bread and butter would be through a notice of deficiency plan of correction process that is primarily administered through the investigations team. And that is as well as testing, as well in the case of ITLs. But that is more so dealing with kind of routine actions. When we're talking about kind of larger actions where we're bringing a formal administrative action against the licensee, where we would be collecting civil penalties as discussed previously, that would be through an order to show cause, a notice of fine, something along those lines. Actions to deal with more kind of immediate or pressing matters that particularly deal with public health, safety, and welfare. Those relate to removal, prohibition of marijuana products, quarantine orders, cease and desist orders, summary suspension orders. We also can move to revoke or suspend licenses, as well as the board is aware. So as Chief Jones identified in a couple of prior instances, we have identified circumstances that were somewhat similar to this action that we're talking about in New York. We've also had other issues where we've dealt with kind of diversion issues. So we have taken enforcement actions in the past on those or in those areas, or when we've identified and substantiated violations of our regulations that relate to those. I will note, to the point that Chief Jones brought up with the kind of unauthorized, in New York, they referred to it as something different, but in our instance, we referred to it as an unauthorized assignment or transfer of a license. So in that instance, there was a marijuana transporter, I believe, that was essentially allowing another entity to utilize their license to complete transfers. So we did take an action in that instance, and that stipulated agreement was approved by the board back in 2021 and resulted in a relatively significant civil monetary penalty. But then beyond that, as we're talking just kind of specifically to the penalty of debarment or the contemplated penalty there, if we were to take an action and revoke a license, for example, under our suitability tables, in particular Table A, there are two provisions in there that identify, or two rows of the suitability table that identify if an individual or entity has had prior registration or license violations in Massachusetts or in another jurisdiction. They are for the first 5 years following that action, and it specifically speaks to the revocation of a license, the failure to renew that license, or a similar action. For the next 5 years, that individual or entity was found to be unsuitable per that table. They are mandatorily disqualified from licensure in Massachusetts. After that 5 years, the standard is lessened slightly. So from between 5 years and 10 years following that action, they are presumed to be unsuitable. So when we're talking about a mandatory disqualification versus a presumptive negative suitability determination, a mandatory disqualification, there were very few instances in which an unsuitable individual or somebody who has been deemed unsuitable is able to overcome that. In essence, it is that we are relying on wrong information or the suitability issue was corrected by the time they are contesting it. When we're talking about presumed, somebody who is presumed to be unsuitable, there are many more factors that the Suitability Review Committee or the Executive Director can consider in terms of whether that person should be actually deemed unsuitable or if they should be allowed another shot at licensure. Beyond those 10 years, however, my understanding too is that we do not have a kind of lifetime ban that this New York option seems to be considering. So I hope that information is helpful as the board is considering kind of what happened in New York, whether that would be transferable over to here, and also just kind of the general options that are available to us at this time.
Okay, thank you, Attorney Gooden. Are you, again, I think that we still, oh, sorry, Commissioner Bennett, I'm sorry.
Thank you, Chair. Just one follow-up question. After 10 years, can a prior regulatory violation still be considered as a factor in evaluating suitability, or after 10 years, does it essentially get wiped clean?
Chief Jones or Attorney Gooden, who wants to handle that? Did you hear that? You want to just restate that question? Mr. Bennett?
Sure. My question is, after the 10 years, can a prior regulatory violation still be considered as a factor in evaluating suitability, or is it no longer considered at all after the 10 years?
Chief Jones?
Thank you, Chair. I think we'd have to look into that because I don't think we've ever really encountered.
We haven't been around that long.
We haven't been around that long. It would be a case of first impressions. So would have to look into that.
Yeah, thank you. All right, thank you. Any other questions or comments? Yes, Chief.
And then the other thing that I wanted to add related to that matter, back in 2021, we also, it wasn't just a monetary fine. We also placed them on a 1-year probation to monitor their activities, to ensure that if there were any future violations, anything like that, or similar violations, then we would take further action. So I just wanted to add that as well.
If we have observed criminal activity and we make a referral, how quickly is that brought to the commission for review? I mean, we don't review criminal referrals, do we? We don't review that, no?
If I may, Chair.
Please.
So in those instances, no, we would not be bringing that before the board, because typically what we do with all our enforcement actions, we wait till they're ripe for the board's review, consideration or contemplation or discussion. So we would not bring that forth before the board to, for the board's consideration, because it wouldn't be ripe, for the final evidence.
It's ripe. Define ripe, because it is, for instance, if a licensee is engaged in criminal behavior and we make a referral and at what point in time does it become ripe? What if they do something else wrong in the interim? Does it just stay open indefinitely? At what point in time, should it take 6 months? Should it take a year? Should it take 3 years? When we are aware of potentially criminal activity, how long before that comes to the commission?
If I may, Chair.
Please.
Is it the keyword potential, right? At that time, as we all know, innocent until proven guilty. So it's not within our jurisdiction for us to look into criminal matters. And then also, we've had instances if they self-identify or they self-report to the staff that they've in fact lodged a criminal complaint with the police department, we would not be the ones to then make the referral because they have self-reported that they've in fact done so. And then also too, it's on a case-by-case basis. So we don't want to prejudice the licensee. If we bring the issue before the board and say, there's an allegation of a criminal complaint and they've in fact not gone through, the due process, it wouldn't be fair to the licensee for us to do that. Again, it comes down to the fact that it's not within our jurisdiction for us to oversee criminal complaints.
But if we've made a see, this is also my concern about what is ripe. And when does the team come to us and how long these take? At what point in time when we've observed and made a criminal referral, we've obviously seen something that could impact the suitability of a licensee. I mean, it's right. I mean, am I correct in assuming that if we have made a determination that criminal activity may have occurred and we make a referral, is that not incumbent upon the staff to say to us or to do something about suitability? What happens after that? If you've potentially observed it and you've made a referral, then what happens in terms of the people that were apparently we could observe that there might be criminal behavior? What is incumbent upon the staff to do to look at suitability to determine whether or not that suitability still remains?
If I may, Chair,
Please,
we have to wait on for the outcome of the criminal complaint from those agencies or that are actually looking into the matter. We have to wait until the matter has been adjudicated in order for us to be able to even get involved in that regard. And also, you're talking about observation. Observation, that means at that point, we're either a witness or we can attest or corroborate to something, which is why earlier I had indicated that in instances where we've made a referral and then the matter proceeds to an action where it goes, before a district attorney and we're asked to testify, we've in fact done so for other criminal complaints that we've made referrals for. And we do not want to be stepping on toes of other jurisdictions for things that we are not expertise on. We're not experts when it comes to criminal complaints. What we adjudicate is matters related to cannabis laws and pursuant to our regulations and pursuant to our laws.
Okay. All right. Thank you. Commissioner Roy, any? Nope. Okay. Thank you. So we will. Well, I was going to say that we will take a break until 11:30, and then we will jump in with both feet to move towards the end here on social consumption. So I will entertain a motion to recess. So do I hear a second?
Second.
Having been moved and seconded, all those in favor say aye. Aye. We are recessed until 11:30. Thank you. Thank you. All right. Now we are coming back to the regulatory changes for social consumption, and I will turn things over to Attorney.
Thank you, Madam Chair. So just before we get into this list of commissioner decision areas, I did want to give the commissioners an opportunity, if there's any other areas not on this list, if there's anything else in the regulations that you would like to address. So I just wanted to open that for the commissioners.
No, but the only thing I will say, and we had a conversation outside. So what the plan is today is we're going to try to plow through this, get this as close to consensus as we can today, but take the official final vote at next week's meeting on the 11th, just so we give the staff time to check that, to make sure that, you know, we've got everything done. And again, I want to thank the team for doing just such a great job, really leading us through. I don't know how you remember this, and you seem to all have, bless you, photographic memories for figuring out what's where in this approximately 160 pages. How many pages do we have here? Although this is legal, so it's probably longer than that. But anyway, I want to thank you once again, and I want to acknowledge the team for helping us with this. You know, Rachel as well, who's been keeping things on track, but in particular, attorneys Bruno and Baker for leading us through this, and thank you. So I will turn that over to you.
Thank you, Madam Chair. And I just wanted to provide that opportunity because I know we did provide and we offered a finalized legal amendment section with our new draft. So just to give an opportunity to commissioners if there was anything in that list or otherwise that you wanted to address. And I wasn't sure, I know Commissioner Stebbins, you and I had spoken about one section. Would you like me to bring that up on the page?
I'm sorry, Madam Chair.
Please go ahead.
If you wouldn't mind, and it's really just more for clarification, and again, trying to make things as clear for our potential applicants as possible.
Absolutely. So we'll start on page 107, and this is 500, 141, 10E5. Which currently reads, odor control equipment sufficient to mitigate cannabis odor from being detected outside the limits of the premises.
Okay, Commissioner Stebbins.
Sure. Again, I know we had extensive conversation about this. You know, how do we do everything we can to mitigate the cannabis odor from being detected outside the limits of the premises? I guess the question I wanted to raise was, if you read through it, you go back up to number 1 under this section, you're talking about a ventilation system. 2 says a separate ventilation system. 3 says a separate system within the rest of the social consumption establishment. Then we talk about the type of filter that we want folks to use. And then we talk about odor control equipment. And I guess I don't want to necessarily send the signal of you've got all these separate systems, then you need odor control equipment beyond that, when the odor control equipment may be part of the existing ventilation system. So I don't necessarily have any language for that, but I wanted to just go back to that and see.
Can you clarify your point? I
Sure.
think I understand, but what are you aiming to get at?
Just trying to
I'm
clarify.
assuming someone provided you with feedback or.
No. I was reading through it, I think yesterday or this morning, actually, while I was looking for something else, and trying to clarify that so that we're all clear, the odor control equipment is in addition to the ventilation system, but it may also be part of the ventilation system. But I know you had, I think, brought up the issue of how do we stop the smell at the limits of the premises. So just trying to offer some clarity for a licensee who might be reading this and say, okay, I need this system, and this system on top of it. So just trying to clarify how we're looking at odor control, whether it's part of the ventilation system or it's something in addition to the ventilation system.
Thank you. Attorney Bruno?
Thank you, Madam Chair. So in just clarifying kind of the scope of where this requirement lies. So this requirement is for indoor smoking consumption areas, and specifically a requirement that lives within the ventilation and filtration system requirements. And so this requirement will be something that's required to be a part of the ventilation and filtration system. And in looking into the research with some of these firms within the industry that provide these types of ventilation and filtration programs, they provide things like carbon filters or electrical charge filters that are part of the ventilation and filtration system to mitigate odor. And so I think to Commissioner Stebbins' point is it might be helpful just to clarify that this is in the language specifically, that this is not a separate system that somebody has to necessarily purchase outside of their ventilation and filtration system. It's probably going to be housed inside of it. And so I would certainly propose, to Commissioner Stebbins' point, we could state odor and control equipment within the ventilation and filtration system sufficient to mitigate cannabis odor from being detected outside the limits of the premises, for that clarity.
Okay,
I like that.
thank you.
I like that.
Are you comfortable with that, Commissioner Benedott?
Thank you. Should we say which may be included within the ventilation system?
If I may, Madam Chair.
Thank you.
Yes, we certainly could, if that is the intent of the board, if you would like to provide the licensees the option to have odor control equipment that's not a part of the vent system, as we do potentially for retailers.
If we did shall, then they have to have a ventilation system that contains odor control.
Yes, so right now, section E, the introductory language states social consumption establishments with an indoor smoking consumption area shall include. And so I would state, to Commissioner Benedont's point, if you would prefer this to be a may, then maybe move it outside of section E and make it its own subsection, if that's what the board would prefer.
Commissioner Benedott?
Thank you. I don't mean to suggest that odor control equipment should in any way be optional. So I'm not suggesting that that be a may. I'm just questioning whether we should require that the odor control equipment be part of the ventilation system in subsections 1, 2, and 3, or whether we should give them the option of having it be, it would be required regardless, but could be part of the other system or could be a standalone system.
I see what you're saying. Go ahead, Commissioner Wright. Oh, sorry.
Reflexively, I want to make it part of the ventilation system. Like reflexively, I want to do that. Like, you know, then it's not ambiguous. Everybody, you know, it's part of your air handling system, odor control. Unless you convince me otherwise.
I just don't know the state of the technology to know whether it can be housed outside of the vent, you know what I mean? The ventilation system is there to purify the air to keep you safe from contaminants. So contaminants is one thing, right? And odor is wrapped up in it, but it could be separate. That's kind of what we're, so I hear what you're saying. I just don't know enough about the state of the science. Because I know, like Commissioner Roy would like it to all be in one place, because then it covers all the problems, but.
No, we obviously go.
I know. Executive Director?
Thank you, Madam Chair. I think if number 5 after odor control equipment just has some caveat that it may be part of the other equipment, then it gives them the optionality.
Yeah. Does that make sense?
If I may, Madam Chair, thank you. So I think in the alternative, we could amend section 5 to read odor control equipment sufficient to mitigate cannabis odor from being detected outside the property lines, comma, which may be contained within the ventilation and filtration system, so that they have the option of it being within the vent system if that's maybe more economically feasible for them, or if the other technology exists, they can use other odor mitigating technology that's outside of the ventilation and filtration system.
See, again, I don't understand enough about the technology to understand, you know, maybe there's something superior. in terms of odor control that may or may not currently be within the ventilation system. And that's the only thing that, I mean, again, I have no idea what I'm truthfully expressing here, but I think that that concept could be valid depending on how this equipment works. Commissioner Wright, I just want to make sure, I think that language from the executive director makes sense, but Commissioner Wright, are you comfortable with that?
I was just looking, is negative air pressure systems are effective for odor control because they pull air into a contained space and force it through filters, which can include carbon filters, specifically designed to absorb odors. So is that the end all be all? Maybe there are other better systems. So this.
But I think that the point is we're requiring that they have odor control equipment sufficient. That's there. And how they do it is up to them. Right.
Okay.
So it may be, I mean, my guess is one-stop shop is probably going to be the most economical way to do it, but it may or may not be scientifically the current best way. I don't know. And there might be things that are developed in the future, but I think that Commissioner Stebbins, are you?
Yes, thank you, Chair. And after this discussion, maybe just leaving the language the way it is allows our licensees, they have to do it. They have to have something that's going to protect odor from emanating beyond the limits of the premises. For them, it might be they find the system, to your point, Chair, it's already included, or they have to add something on. So maybe this language, maybe I've overread it and it's fine the way it is. They have to have it because that's how, as you pointed out, that's how E starts, shall include. So.
Attorney Bruno?
I do think the language is sufficient, to your point, Commissioner Stebbins. And it's also something when we're going through the implementation process that we could, I mean, I'm sure we're going to have to be providing some of this information through guidance. So I think that would certainly be something we could include in a guidance document.
Commissioner Roy?
Commissioner Benedon, you had, through the chair, you had a question about the term mitigate.
Yes, at the last.
Yes. Any other thoughts on that, or you think we're okay where we are?
Yes, so I considered that further and also had a discussion with legal about it. And in reviewing the regulations in totality, I am satisfied that that can adequately be left to the municipalities to enforce, because previous provisions in the regulations do specifically require a plan with the municipality that contains odor control. And so that gives the municipality the explicit authority to address that to their standards.
Right. Just want to make sure you were good. Okay.
And I do think, and this is one of the conversations we were having yesterday when we were talking about the budget with our CFAO in terms of how we're going to actually fund and do some of these things. And there's a lot of education that, we're going to actually have quite a bit of time. And that's one of the things to, I think, really state here is when we ultimately vote on this and then it is sent for promulgation, that is just the beginning. Most of the work, with all due thanks to our legal team and folks, but it's even more work to sort of figure out how we implement this and how we partner with communities to make this a reality. So there is going to be a lot of opportunity to make sure that we get it as precise as possible. So I just want to make sure everyone's comfortable with this language, and I think that we can. Do we have consensus that we can leave it as is?
Sorry for the
this.
quick
No,
sidetrack.
No, but this is, again, I don't apologize for anything like that. Having these conversations, I mean, this is also part of the legislative record or whatever you'd want to call it. I mean, this is, people are going to be looking to the conversations that we have, what we're anticipating, what we're thinking, and it helps clarify what we ultimately put in writing. So I appreciate the conversation. It's helpful. Okay, Attorney.
Thank you, Madam Chair. Do any other commissioners have any other sections that they would like to address before we turn to commissioner decisions on the page guide?
I don't.
Okay. So we will turn to page 100. This is under 500-141-3 on limitations of sales. This is 3B 1 through 3, which I'll read. General requirements, I apologize, point of service limitations. At the point of service, a social consumption establishment shall not serve to a consumer at one time more than one half of the limits established in Massachusetts General Laws, Chapter 94G, Section 7, 935 CMR 500 143A, and 935 CMR 500 144C. A social consumption establishment may maintain an open bill for a consumer, provided that the sale or service of marijuana or marijuana products complies with 935 CMR 500 141 3A2 and 935 CMR 500 141 3B1. A marijuana establishment agent may sell or serve marijuana or marijuana products in excess of the point of service limit set forth in 935 CMR 500 141 3B1, provided, however, all sales and service must comply with 935 CMR 500 141 3A2, and provided further that a marijuana establishment agent shall place all marijuana or marijuana products in excess of the point of service limits set forth in 935 CMR 500 141 3B1 directly into an opaque, child-resistant sealed exit bag prior to being provided to the consumer.
And I will make the statement at this point, which I probably should have stated before. We do know that the legislature is considering some statutory changes, which will also change, will require us to have responsive regulatory changes in the future, because there are daily sales limits, among other things, that will be considered, that will impact what we're working on right now. So just, I mean, obviously everybody here knows that, but just making that statement for the public that we are flying a little bit without, without full understanding of what the statutory changes may or may not be. So we're doing this for now, and in the future, we may have to make some changes to this. So I should have said that before. Commissioner Roy?
Thank you, Chair. And Attorney Bruno, I think this satisfies the conversation we had where keeping it, the bud tender, keeping it behind, or because then we all agreed if it's autometric, it shouldn't be with one of our licensees at that point. It should be with the person who purchased it. So that alleviates that concern and satisfies that. So now it's in this opaque seal, and it's the property of the person who purchased it. And the bud tender does not have custody of it.
Exactly.
Okay.
Thank you. Are there any questions or comments on this section so we can get consensus? Do we have consensus that this language is? Thank you. So moving on. Thank you.
Okay, so we will move to page 102 for 500 141 3D5. This is the discussion for process for commission approval of other items, which reads.
Can we just go back? Did I miss? Did we just encompass? Can you just go back up? I just want to look at that on. Are we going to 102 or are we skipping 101 right now? Wait a minute.
I'm sorry, page 102. So we're still in 500 141 3. We'll be now in subsection D5. So we covered all of B1 through 3. As far as the 2 beer rule.
Okay, all right. So so you're comfortable with that? I just wanted to.
That everybody's comfortable?
Yes, everyone is comfortable with that. Okay, all right, thanks.
Okay. Thank you, Madam Chair. So subsection 5 reads, excuse me, sale and use of accessories. I'm so sorry. Sale of other items and consumer support items. A social consumption establishment may sell items not expressly authorized herein, including measures reasonably intended to alleviate or mitigate the effects of intoxication, only after receiving the express written permission of the host community of the supplemental on-site social consumption establishment or hospitality on-site social consumption establishment, or for a marijuana event organizer, the municipality where a temporary consumption event is located. With that in mind, the page guide also includes some proposed amendments which have come from the commissioners, and so I'll certainly read that as well. So the changes on this here are redlined as well. So sale of other items and consumer support items. A social consumption establishment may sell items not expressly authorized herein, including products reasonably intended to alleviate or mitigate the effects of intoxication from marijuana or marijuana products, only after receiving the express written permission of the host community of the supplemental on-site social consumption establishment or hospitality on-site social consumption establishment, or for a marijuana event organizer, the municipality where a temporary consumption event is located. Provided, however, that the sale of any items not expressly authorized herein complies with 935 CMR 500-141-9. Such express written permission shall be submitted to the commission. That would be in strike in pursuant to 935 CMR 500-101 3I8 and updated upon any change in accordance with 935 CMR 500-104 subsection 5. That would also correspond to a separate requirement upon the submission of an application for a social consumption establishment, which reads, and I'll discuss afterwards, which would be 500-101 3I8, which reads, applicants for a social consumption establishment license shall submit a copy of the express written permission of the host community or municipality for the sale of other items or consumer support items as authorized in 935 CMR 500-141 3D5 if applicable. And so this was some response that we received from Commissioner Roy as to a request that any express written permission that the licensee receives from the community should be provided to the commission in some way. And so with that in mind, legal thought it would be appropriate for any express written permission received to be included in the application process. And then separately, there is a provision within the regulations at 500-104-5 that requires a licensee to update any documentation with the commission. And so if there's any changes to what the licensee is permitted to sell, the commission would be notified.
I am comfortable with the language that you have put together here, Commissioner Roy.
I know, and I know we had this conversation, but so do we need to make the licensees ask permission to carry the host community? Like, we just want somebody to sign off on it. In other words, like the undo and the soft landing that they all say they want to have. We're asking them to get permission from the host community. But do we need to make them get permission from the host? Like, I don't want to disincentivize it so they won't carry it.
Yeah. Executive Director?
Thank you, Madam Chair. I'm reading this more as if they get something in writing that they must provide it to us. The shall is for them to submit it, not that they must get it. Am I misreading that?
If I may, Madam
That's
Chair,
what
I think what Commissioner Roy is indicating is more towards the language up top.
Yeah.
Is at the beginning, a social consumption establishment may sell items not expressly authorized herein, including products reasonably intended to alleviate or mitigate the effects of intoxication from marijuana products. The legal had proposed that this be housed here because it is a product that's separate from what the commission regulates within its jurisdiction. And when we were thinking about other items that a licensee would be selling, for example, I know we oftentimes use the yoga studio if they're selling yoga mats or the socks with the sticky grippers. If we need to, if the commission as a policy would prefer to have to sign off as the commission for every item that a licensee wants to sell, if it's not really related to marijuana or marijuana products. If Commissioner Roy, if you would prefer that this be removed from this particular subsection, we could certainly work with that. We've housed it here because it's those products, those THC inhibitors, I don't think are something that the commission specifically regulates itself, which is why we had housed it there with the other products.
Commissioner Roy? The bottom line is, what do you,
My only concern is I don't want to disincentivize.
you don't want to create barriers to them, say, we're not going to answer the.
Yeah, it's a pain in the neck. We're not going to carry these now, but can we break them into like? I understand like all the other items and there could be a slippery slope there. So you want the host community to be okay and let us know. I asked for that provision. But I just don't know if there's a way to.
So I think that you're saying that this is different than a yoga mat, that it might be rationally related to.
That's what I'm saying.
Share, that's exactly what I'm saying. Problem, even though, and these, and I don't know, this, one of the things, Commissioner Benedon, that I learned when we went on, one of our road trips is that, some of these, there's still a question as to whether or not this truly mitigates the impact, of cannabis, but that there could be a placebo effect. I mean, it's still, it's a little bit, I take zinc, you know what I mean? And no one has necessarily definitely proven that it stops you from getting a cold, but, I take it because I believe it might help me. So, and I think that this is kind of in that homeopathic category where we don't want to mandate it because, but we want to make sure that it's allowed.
Right. And does it make the commission, give assurances if the host community signed off on it? Is that what we're looking for here?
Well, that's what I'm saying is that's what I initially, when we were talking, I thought it was, I wasn't paying, honestly, I wasn't paying attention to these remedies. And I was thinking more of the other things that let the community determine what they can and can't sell. But I do think that this is a little bit different than yoga mats or bubble gum or anything like that, because leaving that to the community, then we leave it to them. I mean, I have no problem, and I've talked to some former commissioners about why they even did have some prohibition on selling candy or something like that. And again, that was the potentially over restrictive, overly cautious in the beginning. I don't have a personal problem with that, but leaving it up to the community. Maybe, someone is opening up a store, but then all of a sudden they're selling everything that's 7-Eleven. Right. But I'm just saying they can determine kind of the zoning and competition that's
I agree with that.
happening there. But I do agree with you that this could be a little bit
I
different.
just don't want to disincentivize it.
No, I agree. Commissioner Stebbins?
Thank you, Chair. And I agree with Commissioner Roy. I mean, if the evolution of these products, and I think we all agree that the science still may not be proven on some of these, but if we get to a point where some of these products are proven and work well, I'm wondering if we can divide 5 into an A and B. A to say you can sell those products. B, anything else might require the host community to say, we don't want you to compete with the hardware store next door or whatever.
Attorney, Attorney Baker.
Thank you, Madam Chair. This is an excellent point. We've wrestled with this on the drafting side of things. So the reason why we married them together is obviously anything outside of our jurisdiction will defer to the municipality here to sell. That makes sense. I think that's clean. The issue that we're coming into is that the way it's drafted, obviously we can work on redrafting it to accommodate for this, but products reasonably intended to alleviate or mitigate the effects of intoxication, that could be anything because there's no standard here. And, that was intentionally loose to allow for products that would mitigate THC effects. But when we frame it as such, then that kind of butts into what we're allowing down below. And there's a bit of overlap here between the two. So marrying them together and leaving it up to the municipality made sense when we were drafting.
Yeah, but I think, because we know that the science is not hard science, but we're sort of in that world right now, right? So
soft science.
But I don't know, I think it was it Commissioner Stebbins or who said that maybe we make it 2 different sentences because water, I don't think that it, we want them to have water there and that frankly could be one of those remedies, right? And I don't want them to have to get permission to make water available, even though the 7-Eleven might be 60% of their business is selling bottled water. So is there a way that we could reasonably separate this to not discourage that? I do believe that in another place we have mandated water, right? Did we mandated that someplace else? Yes, we did. We mandated that someplace in here.
If I may, Madam Chair.
Please.
Yes, so the licensees, social consumption establishment licensees will be required to provide shelf-stable products, including food and water, to consumers. I think I'm hearing that there's consensus on splitting the two, and so during a break, we can put together some language and revisit this section to present that to the board. I think we can do that today.
And again, whatever we can get done today, we'll get done today, you know, but to just make sure we get it right. So thank you. All right, so moving on, and we will get that language as we do. Attorney Bruno.
Thank you, Madam Chair. If we could move to page 103. And this is 500-141 4K. And this is in regards to exit bags for liquids. So just before I read this subsection, I'll give kind of some context. So when legal is doing a control review of these regulations, this subsection does require the social consumption establishment to offer an exit bag to consumers. One thing we were doing some research on is whether there's any product that is opaque, child resistant, and able to be sealed for any open beverage, which is something that's manufactured and comes pre-infused, like a cannabis seltzer, for example, that's a can that's cracked, or a drink that a consumer in a glass that a consumer will infuse by themselves at the social consumption establishment premises. And we could not find really any feasible market items that would be sufficient as a to-go bag for liquids. And so we've proposed this language here. The social consumption establishment shall offer consumers an opaque child-resistant sealed exit bag to take unconsumed or partially consumed marijuana or marijuana products from the premises, provided, however, that any open beverage or any drink or other liquid that becomes infused by a consumer on the premises shall be consumed on site and may not be removed from the premises. There has been an amendment proposed by Commissioner Stebbins, so I'll read that here as part of our page guide. The social consumption establishment shall offer consumers an opaque child-resistant sealed exit bag to take unconsumed or partially consumed marijuana or marijuana products from the premises, provided, however, that any open beverage or any drink or other liquid that becomes infused by a consumer on the premises shall be consumed on site and may not be removed from the premises unless secured in an opaque child-resistant sealed exit container suitable for liquids provided by the social consumption establishment. I'll certainly allow Commissioner Stebbins to,
Yes.
I won't speak for her. I won't steal his thunder.
Right, Commissioner Stebbins?
Thank you, Attorney Bruno. The thinking here was just, hopefully it's someday kind of keeping up with the availability of technology. We did have a chance to get some feedback from a company that makes a seal to put back on a canned beverage, which also obviously will be available at a social consumption establishment. So kind of leaving some language in here of, I have some of my beverage left, I have to leave. I think Commissioner Roy always points to, I get a call, I got to dart out the door. Do I want to swig this back? Or do I want to allow myself to have it packaged, child-proof container, opaque container, and I can leave with it? What I wanted to offer here was just language in case, the technology comes along that somebody can reseal a beverage and make it child-proof and opaque, that I'd want to offer a consumer that opportunity as opposed to feeling like they have to, hate to say chug, but chug or finish off a beverage before they run out the door.
Commissioner Roy?
Are you good with that?
I'm good with that.
Yeah.
Commissioner Benedict?
Yes.
Good work, Commissioner Stebbins. Leaving room for innovation.
If I may, Madam Chair, There's, I think, one other appropriate amendment relative to that, that Commissioner Stebbins also pointed out on page 99 in regards to the SOP section relative to exit bags. This would be 500-141-2I, and it currently reads, procedures to ensure that marijuana or marijuana products purchased on site do not leave the premises except as otherwise authorized in an opaque child-resistant sealed exit bag under 935 CMR 500-141 3B3 and 935 CMR 500-141 4K. I think the appropriate amendment there would be to include sealed exit bag or container sufficient for liquids, so that it includes both the exit bag for product as well as liquids.
Thank you. Any questions on that? Moving on.
Thank you, Madam Chair. The next section is cooling down areas, and we'll go to page 5 for the definition of cooling down area at 502. Which reads, cooling down area means a space that a social consumption establishment may offer within its premises, whether permanently designated or temporarily created as needed, where consumers may safely recover from actual or suspected overconsumption of marijuana or marijuana products. And if you prefer, Madam Chair, I can read this in conjunction with the SOP in the social consumption establishments section so that the board has the full context, unless you would prefer to discuss this.
I'd almost prefer discussing it right here because, and I just will offer, and I know that this is something that has been, important to Commissioner Stebbins, but the more I've thought about this, the more I think that this is exactly not what we want. I want them to be able to steal their drink and leave. I don't think that if someone is overserved or overconsumed, that we want them staying there for any reason whatsoever. Licensees have a duty spelled out in other places where they have to have a transportation plan and get them home. I don't see how we make this function even on the May offer, because I think that it sends the wrong message to social consumption establishments, like, oh good, we can keep them here and sell them more stuff. I think it sends the wrong message. So I'm opposed to all this language. And so, we can kind of wrestle that, but I'm not comfortable with this language at all. And I don't think that it sends the right message that we want people to stay when they've overconsumed, and we have people that we don't even know what all the training is going to be for people. We don't know where they're going to be. We don't have any, you know what I mean? I just don't think that this is smart for us to say that any place should do anything other than send people home if they're overserved. So Commissioner Stebbins?
Sure. Thank you, Chair. And I think we will, again, I don't want to necessarily, and certainly heard the arguments from our previous meetings about requiring this, leaving this up to the establishment, that if somebody is having an adverse reaction, and some of that it becomes anxiety, some of that becomes panic, even if we are following the transportation plan that everybody will be required, they may feel, or they may want to offer their customer a quiet place to step out of the consumption area, and it might be while they're waiting for a car. And I think we do address the second issue that you brought up in terms of some of the allowances, or if you are going to offer this space, certainly we talked about it, it would not be in a restricted area, and that we would not, and that the licensee wouldn't, anybody who chooses voluntarily to go into this space would not have the ability to purchase or consume any other marijuana or marijuana products if they've taken advantage of using the cooling down space. And I think we cover that somewhere else in the regs. So again, it's leaving it up to each licensee, leaving it up as some element of their hospitality that they might want to afford, a consumer, again, who's having an adverse reaction.
If we don't,
But I do hear,
if we don't include this, are they precluded from doing that?
I think the language we have now would allow them to do that. I think defining a cooling down space and then following it up with where we would allow, because I know we had a question around, it can't be we're not going to allow you to calm down in a restricted area like back in the vault or anything like that.
I
But
think it creates new areas of liability that we don't want to create. I mean, if it's there, well, again, I think that it is not good policy. And I think that if someone is, it's just like, I mean, when we think of hospitality, I think of going into a bar.
Mhm.
And we don't do this at a bar, or do we? Are there any instances that you know of where we do this at a bar?
not that I'm aware of, but I would say that some of the symptoms or reactions that you can have from cannabis different from what you can have from alcohol.
Agreed, meaning people can stay because it's different.
People in a bar or people who went.
People in a social consumption establishment. I don't think that encouraging people to stay makes sense. Because we don't do that in bars now.
Mhm.
If someone is overserved, depending on, whether it's anxiety, whether it's, heart racing, I mean, obviously different physical manifestations of consuming or over consuming. But I worry that this language, and I worry about the additional time that it's going to take to clarify this, doesn't create greater safety or protection for consumers. That it's just, again, it's, I don't think it makes sense. Even at the May, I don't think it makes sense. Commissioner Roy?
Maybe would this be more appropriate in a guidance document? As opposed to,
I'd be comfortable with that. Would you be comfortable if it's in guidance?
I've always thought there would be a guidance component related to this, but I think we're going to refer to it in guidance. I think we have to allow at least some reference for it in regulation. And again, with the flexibility being left up to the licensee as to whether they want to make it available and, and thereby assume the liability.
See, my problem is I think that they could have an incentive to keep people there. And I don't like any incentive if someone is overserved. I don't want any incentive. Maybe if we have language that if you go into a cooling down space, you can, do we have that someplace else? You can no longer.
You can't.
That's what I'm.
Consume it.
And so how are we who's policing that?
I mean, that would be up to the licensee if they do offer it. And I have a bad reaction and they invite me to, you take advantage of the cooling down area and I choose to. It means once I'm in there, whenever I leave, and again, it's up to the consumer, I can't consume anything or buy anything after I've been in it. And that's on the onus of the licensee to make sure that doesn't happen.
Attorney Bruno?
Thank you, Madam Chair. Just to Commissioner Roy's question about whether this could be in a guidance document, I think that somewhat depends on what the board sees as potentially being included in that. For example, right now, the SOPs indicate that, for example, a cooling down area cannot be in a limited access area. And Commissioner Stebbins has also indicated that he would like an amendment that a consumer who uses the cooling down area cannot be permitted to purchase additional marijuana or marijuana products. So I guess the point being is that if we're including things that are restrictions on what the licensee can do, the guidance document won't have any force of effect. And so if if a social consumption establishment chooses to use a cooling down area, and if the board would like to place any sort of requirements on that use, if they choose to do it, then it would be more appropriately housed in regulation with further explanation and guidance. But if it's just in guidance, there would be no teeth for enforcement.
Commissioner Ray?
Can you repeat the SOP language?
Yes, thank you. I'm happy to go through that section. I just wanted to, of course, defer to the chair.
But I will point out that when we were doing chapter 1 any regs, I did write the guidance for host community agreement models before we finished the regs. So there is precedent for doing guidance before we do the regs. So
Oh, okay.
So we can move to page 100 at 500, 141, 2P. And this is social consumption establishment, written policies and procedures. And P reads, if a social consumption establishment elects to offer a cooling down area, procedures for providing a cooling down area upon the request of a consumer, where the consumer may wait for the effects of consumption of marijuana or marijuana products to dissipate. Use of the cooling down area shall be at the discretion of the consumer. A cooling down area shall not be located in a limited access area. And I'll further read the amendment from Commissioner Stebbins, and which would immediately start after use of a cooling down area shall not be located in a limited access area. Consumers using a cooling down area to mitigate the effects of the consumption of marijuana or marijuana products shall not be permitted to purchase or consume any additional marijuana or marijuana products on the premises.
Commissioner Roy?
So I have a question because it's voluntary to enter it, but then you're involuntarily can no longer purchase. So you're getting penalized. You're involuntarily going to that chair, which is the designated cooling down.
What if they revoke the voluntary?
And so, but then I am prohibited from purchasing. So that's where I struggle a little bit. It's like punitive. I don't know if anybody sees it that way, besides me, but.
Commissioner Benedon?
Thank you, Chair. I share some of the concerns that Commissioner Roy and the chair have expressed, and in particular, regulating something that is completely optional and discretionary on the part of licensees. It makes me wonder whether this is something that would ever be utilized, because if they opt to provide the space, and now it's a space that is in the regulations, so they have to have an SOP and they have to submit the SOP. It's hard to see why they would do that. Plus, there's the concern about the use of it. Even if the licensee were to offer it, then the use of it has this somewhat penalizing impact. Whereas if it's not addressed in here at all, there actually may be more incentive
Do it.
for a licensee, a social consumption establishment, to have such a space, to just have a couple of armchairs in the front in a non-consumption area. It seems that the goal would actually be better served by not regulating it.
Guidance. Do you think in a guidance document, if I may, Chair?
Please, thank you.
Do you think in a guidance document or not at all? And you're right, because if it's an SOP, and to DGC's point, or Attorney Bruno, I can't remember, if it's in guidance, then can't really enforce. So now someone's going to subject themselves to an NOD because they got a broken armchair. You know what I mean? It's like now they're going to subject themselves to getting written up for an NOD based on their not following their SOP around that. So just to your thought.
Commissioner Benedon?
And I think I would ask the question, perhaps of legal, if we don't include any reference to a cooling down area, either in P or in the definitions, would you agree that nothing in the regulations prohibits an establishment from functionally having such a space?
If I may, Madam Chair.
Please, thank you. That was.
There would be there's no express prohibition against having a space. It would be something that is permissible, as it wouldn't be regulated. So if there's no express prohibition, I don't think that the establishment would be prohibited from creating some type of area on their own.
That's, go ahead.
And I just want to emphasize that I think I very much share Commissioner Stebbins' policy goals. I'm just concerned that this approach doesn't accomplish them and actually might be counterproductive. Right.
Commissioner Roy?
And I agree, Commissioner Bennett, and I, applaud Commissioner Stebbins, because we do agree with the policy goal. It's how do we get there where we don't disincentivize folks? And I have evolved on this too, because hearing, we heard pretty robustly and strongly when we had that public hearing of how folks felt about it. And it made me really step back and think about this more. And I think I think that they'd be less inclined to do it, but they still have the option to do it. And I think leaving it here will be counterintuitive to what we're trying to accomplish, if that makes sense.
And I appreciate the work that Commissioner Stebbins has done on it, because I believe that this is pro-public safety. I think that it, is trying to understand the differences between alcohol and cannabis in terms of the effects, but I'm just not comfortable, even as a May, in terms of what we're going to have to do and how we can or cannot enforce it. And I think it creates an enforcement problem for us and for municipalities. So do we want to gain consensus? I mean, I unless we want to. Please, thank you.
At some point when we break for lunch, I'm happy to just connect with legal and kind of walk through some of the other concerns I might have and see if we can come back.
Hey, sounds good. Okay, all right, thank you. All right, we can move on. Thank you.
Thank you, Madam Chair. So we will move to page 107. This is 500-141-10 indoor smoking consumption area requirements. And this is in correspondence with 500-141-11 outdoor smoking consumption area requirements.
Page
107.
Page 107. And this is 500-141-10B. On page 107, the corresponding language for outdoor smoking is at 500-141-11D. But for purposes of ease, we'll look at just the indoor smoking at B. So this section reads, social consumption establishments with an indoor smoking consumption area shall provide marijuana establishments with adequate personal protective equipment and shall provide options to marijuana establishment agents to view the indoor smoking consumption areas in a smoke-free and vapor-free area. A social consumption establishment shall not prohibit or restrict a marijuana establishment agent from wearing or using personal protective equipment while working in or around an indoor smoking consumption area. The consideration here was adequate PPE, and if the board felt comfortable with the language as drafted.
Can you just raise for us what, and again, adequate PPE, what some of the issues are that we had discussed, because we may not have all benefited that.
Thank you, Madam Chair. And some of the issues that we are facing here is that because cannabis smoking lounges and cannabis smoking in public spaces is so very new, there is not yet a standard developed as to per se specific recommendations as to PPE. This is also an area that is in OSHA's jurisdiction for worker safety. So being mindful of that is their realm to set the standard of what is appropriate for cannabis workers. But my understanding is that the board does want to be proactive in some sense to allow these marijuana establishment agents to have some form of PPE. And so that was the consideration here as to whether the board wish to expand on a standard. And of course, we've discussed kind of the hurdles with that, with the status of the science. I did forget to read an amendment suggested by Commissioner Roy.
Yeah, thank you.
So I will read that here as well. So this would be after a social consumption establishment shall not prohibit or restrict a marijuana establishment agent from wearing or using personal protective equipment while working in or around an indoor smoking consumption area. A social consumption establishment shall comply with all applicable OSHA requirements. And I won't steal another commissioner's thunder, so I'll.
Yeah, thank you. And I appreciate that. Thank you for that. And ironically, I attended a holiday dinner last night for a charitable board, and a person who serves on the board with me also works for OSHA. And he said, hey, I want to talk to you. I just recently was at a cultivation site and they're doing more now. And so that was part of the reason why I wanted to add this language, because I feel OSHA is getting into that lane more, and there might be more things forthcoming around as we learn more about cannabis dust, we learn more about occupational hazards. So just so that licensees, if new protocols come out from OSHA, that they have to adhere to them. But it does sound like OSHA is getting more involved. So that was good to hear.
That is good to hear. So any questions or comments? I mean, obviously, this is something that we don't have fully defined science or standards, so we have to use our best judgment for what we have right now. I think that this language, does anyone have any questions or comments? I think that Commissioner Benedict?
Thank you. I do have one question, which I don't know if legal would be able to answer, but by writing in this provision, a social consumption establishment shall comply with all applicable OSHA requirements. Are we then bringing OSHA compliance into our enforcement jurisdiction? So if there is a violation of an OSHA requirement, then now there's a violation of this provision of the regulation.
Commissioner, I believe we bring in OSHA in other areas of our regs as well. So we've already referred to them in other areas. So it would be consistent in that regard, but that's a great question. Thank you.
It's a very good question, but it also, I mean, this was actually one of the things where, for a number of months, we did not know about the fatality of a woman who passed away in Holyoke. And, we had to call OSHA to say, why are you not doing this? We understand why they're not doing it, but it's good news to hear that they actually are. So it is elsewhere in our regs, and it is good news to hear that OSHA is being more proactive to do that, which is good.
I'll schedule a meeting, or I could choose with this friend here who could kind of bring us to speak with them in Massachusetts.
Yeah, that would be helpful.
Yeah.
Thank you. That would be good. Any other questions or comments on this particular section? If not, I think we have consensus.
Thank you, Madam Chair. So the next section is page 108. This is subsection I. For ease, I'll read the redlined version in the page guide. And these were some suggestions from both Commissioner Roy and Commissioner Stebbins. So upon any failure or improper functioning of the ventilation or filtration system or any alternative ventilation and filtration plan in an indoor smoking consumption area, a social consumption establishment shall immediately cease the consumption of all marijuana or marijuana products in the indoor smoking consumption area. No consumption of any kind shall occur in the indoor smoking consumption area for a minimum of 48 hours following the detection of the ventilation or filtration system failure or improper functioning, or the failure or improper functioning of any alternative ventilation and filtration plan, provided, however, that beginning 48 hours after the detection of such failure or improper functioning and continuing until the social consumption establishment has complied with 935 CMR 500-141-10J, the indoor smoking consumption area may be utilized as an indoor non-smoking consumption area. Notwithstanding 935 CMR 500-141-10I, operation of the indoor smoking consumption area may resume at any time if the social consumption establishment has complied with 935 CMR 500-141-10J. And the considerations for the board here are really, so if there's an indoor smoking consumption area and the ventilation and filtration system fails, would the board require as a policy ceasing all consumption or just the cease of any types of smoking? And if all consumption is stopped, would the board as a policy like to allow the licensee to use that area as an indoor non-smoking area And if so, is there a window of time that the board would like to see as a policy for a window to allow smoke to dissipate? And so legal had done some research as to smoke dissipation. We could not find any research specific to cannabis smoke. We did find research related to tobacco smoke from 2014, specifically with tobacco smoke in households. So generally where there was a one household member smoker, and the study looked at how long it took for at least half of the smoke to dissipate in the home, and as well as how long it took to meet World Health Organization standards for safe particulate matter exposure. And so to meet at least half of smoke dissipation, it took between 2 to 3 hours, and for the World Health Organization up to 5 or 6. The World Health Organization standards has since significantly decreased, so it's a harder standard to meet. Because there's limited research on this particular topic, we wanted to have some basis to provide the board with a window of time to allow smoke to dissipate if the filtration system fails. So we originally proposed 72 hours, whether that's more prescriptive or less prescriptive than the board would prefer. And I'll allow Commissioner Roy to speak to her point.
If I may.
Commissioner Roy.
Attorney Bruno, that sounded great. I feel this strikes a good balance. I think it might have been a little too draconian before. I think you had concerns about that, Chair. So what we're saying, as opposed to 72 hours, let's go to, because the science isn't truly settled on that either, 48 hours. And I appreciate, Attorney Bruno, all your research into looking at the half-life in particulate matter in air. So, and you know, so I appreciate that. So I had said, let's go from 72 to 48. It's a little less draconian. And then also after the 48, if the air handling system is not fixed, that can convert to just, you know, non-smoking until the ventilation system is properly fixed. So I thought this was a nice
I think
balance.
it's a good compromise. Any questions, Commissioner Stebbins?
Thank you, Chair. And, you know, the additional language notwithstanding, we just wanted to make sure that if you did get your system fixed, you didn't have to wait the full 48 hours. And
Right.
that wasn't necessarily clear in the language. I do want to go back only because I'll blame you, Attorney Bruno, for raising this. Do we want to see all consumption of marijuana or marijuana products, or do we just want to cease the smoking?
Commissioner Roy?
So that goes to the half-life of what's left in the air. So the air handling system goes down. It doesn't automatically dissipate and go away. There is a half-life that has to. So that's why we're saying, because indoor smoking is banned in bars and restaurants, the legislature made a carve out for indoor smoking for cannabis, but based on these air handling systems, that's the big caveat. And if that goes down, then the smoking, but the environment is still filled with that secondhand smoke. And so let's give it that 48 hours.
Sorry if
Yeah.
So the intention is completely vacate the area, even if you were in there having an edible, because the smoke isn't leaving and you're still exposed to it.
I think it's considered that the smoke
Yeah. is bad
for your health and
the worker safety too,
Workers.
right? Because if the patrons still stay there and consume, the workers are exposed to it in that area.
are you comfortable with that?
Yeah.
Okay.
Makes sense.
Okay.
Thank you.
Quick questions.
Commissioner Benedict?
Looking more closely at it now, I agree that is the intention, and I think that's the right intention, but I'm concerned about whether the language adequately states that. So maybe there's another provision I'm not seeing. It does state that upon the failure or improper functioning, all consumption must cease and may not resume for 48 hours, 72, but we're changing to 48. But I don't see that the language states that the area needs to be immediately vacated. Is there another provision I'm not seeing? Because I think that is our intention,
That is our, yeah.
but I don't think that the language currently does that.
Assuming if they can't consume, they're gonna go home. But
But the workers say they
yeah, the
don't.
workers say, yeah,
They're gonna be in that environment.
Yeah.
So yes.
yeah, no, that's a good point.
So maybe we need a proviso.
They can't just sit around for another 2 hours and chat or hang out.
Commissioner Stebbins?
Thank you, Chair. I think at the end of that first sentence shall immediately cease the consumption and after consumption area and say the area shall be vacated or something to that effect.
Attorney Baker?
Thank you, Madam Chair. Can we work on this offline and
Yeah.
come back
Yes.
with a new draft?
Okay. And again, we're in a good place right now. We're gonna.
Yeah.
Okay. All right, keep going.
Madam Chair, those are all of our commissioner decision areas. So what I would propose is on a break, there are some sections that legal can work on and bring them back to meeting if we have an opportunity for a break.
I think it is an appropriate time to get lunch. So, Commissioner Benedon, I would entertain a motion for a brief recess until, how long, we could take a,
Time.
yeah, we could,
Almost an hour.
all right.
Eat and do this.
So, all right, so it's 12:45 now. Do we want to say 1:45? Is that good?
Give you enough time.
Yes.
Excellent motion. Do I hear a second?
Second.
Having been moved and seconded, all those in favor say aye, aye, the ayes have it.
So you'll be working
Right, we are.
Oh, one thing I did want to say, Mr. Executive Director, in asking, in asking the chief for the list of all criminal referrals, I'd like not just, I'd like that to understand what the referrals are for. So if we can do that, please.
You mean like getting the actual referral?
Yeah, I'd like to be able to see what was, if it's not confidential, I'd like to, yes, I'd like to see what it's for.
Okay.
Yeah.
Thank you, Madam Chair. I think what I'll try to do, most likely, it's gonna take a little bit to compile, and so we'll probably start most recently and go back, and then anything that's open may have the 30A caveat, those types of things. So I'll try to start compiling going back, because it is going to be relatively manual, but we've started to look at it.
Okay, are there that many?
We're going to have to go through individual licensee filing due to what our project management system looks like. So we're going to have to manually go through all to compile. So I can't tell you a number right now, but it
Go through like hundreds.
enforcement actions. We'll start most recently and go back and we'll compile a list and try to add as much information as we can.
Okay. All right, thank you. I can hear, okay, it stopped, okay. It just like, I was hearing this like weird myself, so anyway, all right. Attorney Bruno will reconvene, and again, we are getting through earlier than I thought we would today, but we will be taking a final vote to make sure that everyone gets the chance to dot the i's and cross the t's, although substantively we are almost there. So that's why I don't want you to worry. We're going to get this done. And we have time with the Secretary of State's office to get this in before Christmas. So, Commissioner Roy?
So just for clarity for people listening, so the vote will be December 11th?
December 11th, we'll be taking the final vote. We're going to be working out any differences we have today, going back to the legal team, just making sure that we're all ready, wrapped up and ready to go. And then we will also be announcing the sort of unrolling process of once this gets promulgated, what will we be doing immediately after that. So we're going to make this one big package coming up on the 11th when we're done. Okay, Attorney Bernal, thanks.
Thank you, Madam Chair, and thank you for bearing with us with a little more time over the lunch break. Based upon the discussion earlier this morning, the legal team has provided some updated proposed amendments. And so we'll look at the page guide that has been provided. Will be in the draft regulations. This would be on page 102, 500, 141, 3D5. So I'll read this proposed amendment. Access to consumer support items. A social consumption establishment may provide access to or sell products intended to assist consumers in alleviating or mitigating the effects of intoxication from marijuana or marijuana products. Provided, however, that the social consumption establishment shall maintain documentation demonstrating the basis for the product's intended use, including but not limited to manufacturer descriptions, product labeling, or other materials, which shall be made available to the commission or the municipality upon request. Consumer support items shall not be marketed or represented as medical treatment and shall be offered only in compliance with all applicable laws. The subsection 6 appropriately eliminates the language addressing measures reasonably intended to alleviate or mitigate the effects of intoxication based upon the proposed language in 5 above.
Okay, thank you. Okay, any questions or comments? I think that this kind of gets at the science or where we are right now. Commissioner Stebbins?
Thank you, Chair. Just based on my conversation with the legal team, I think it meets my suggestion of kind of breaking out the two between other items that the community can have some oversight and approval of versus, I think to Commissioner Roy's point, we do want to make sure that licensees can make some of these other products available and not disincentivize them from doing that.
I think this is a good suggestion. Any questions or comments on this language? You fought with it again, and I think it does it over. Yeah.
This up.
Well, no, I mean, and obviously this is not easy, and it's the science, and we're grappling with a lot of things being open-ended right now, but we're doing the best that we can within those constraints. So I appreciate that.
Yep.
All right, we have consensus. Thank you.
Thank you, Madam Chair. The next amendment would be on page 108, 500, 141, 10I. And this is to address the requirement to vacate the consumption area, but I just wanted to give the context that we also wanted to make sure we include the ability of marijuana establishment agents and maintenance and repair persons to be able to come in to fix the system. So I'll read this amendment in full. Subsection I, upon any failure or improper functioning of the ventilation or filtration system or any alternative ventilation and filtration plan in an indoor smoking consumption area, a social consumption establishment shall immediately require all consumers to cease consumption of marijuana or marijuana products in the indoor smoking consumption area and shall ensure that the indoor smoking consumption area is promptly vacated by consumers. Subsection 1. The indoor smoking consumption area shall remain closed to consumption unless and until the ventilation or filtration system or any alternative ventilation and filtration plan is repaired and functioning appropriately, and the social consumption establishment has complied with 935 CMR 500 141 10J. Just for edification, that is the requirements to show the commission the system is now functioning properly. Subsection 2, during the period of closure and in accordance with 935 CMR 500 141 10I1, the indoor smoking consumption area may be entered only by marijuana establishment agents, outside vendors and contractors, agents of the commission, commission delegates, state and local personnel acting within their lawful jurisdictions, and police, fire department, and emergency medical services personnel acting in the course of their official duties. Subsection 3, no consumption of marijuana or marijuana products shall occur in the indoor smoking consumption area for a minimum of 48 hours following the detection of the ventilation or filtration system failure or improper functioning, or the failure or improper functioning of any alternative ventilation or filtration plan. Provided, however, that beginning 48 hours after the social consumption establishment notifies the commission of such failure or improper functioning pursuant to 935 CMR 500 141 8B6 and continuing until the social consumption establishment has complied with 935 CMR 500 141 10J, the indoor smoking consumption area may be utilized as an indoor non-smoking consumption area. And again, for edification, 141 8B6 is the requirement for the establishment to notify the commission that the system has gone down or failed. Subsection 4, notwithstanding 935 CMR 500 141 10I, operation of the indoor smoking consumption area may resume at any time if the social consumption establishment has complied with 935 CMR 500 141 10J.
That's good. Good work. Anybody have any questions or comments? I think you did wonderful craftsmanship here.
Thank you, Madam Chair.
And has it, Commissioner Benedon, this?
Yes, yes, I think this is great.
Okay, you're good call. All right, so I think we have consensus on that.
That is all we have, Madam Chair.
Wow. Big moment.
Just because, if I might, Madam Chair.
Please, thank you.
The conversation, obviously, and let me express my appreciation to my colleagues for their indulgence as we went through a lot of good discussion around the cooling down spaces. What I felt comfortable with the end of the day after sitting down with our legal team is we will strike cooling down areas. And I did that, or I agree with that only because of other provisions that we have under 141, 2N and 2Q, which speak to response procedures that are going to be involved in a licensee's SOPs, as well as, the transportation plan, as well as when I look at the RVT training, and I know you, Chair, and I are on that working group, the flexibility in there for us to outline procedures for addressing medical or public safety emergencies as part of the RVT training, as well as such other areas of training as we may require. So I feel comfortable with that as an alternative or a solution, as opposed to, the requirements for the opportunity for the availability of cooling down spaces. So
Thank you.
again,
I
appreciate my colleagues for the discussion and feel comfortable that we might be able to get at the issue in two other forms.
And just to, so in terms of RVT, obviously we, we mandate that there be responsible vendor training. But in terms of the actual content, we don't, how do we, I don't know, how do we do that in terms of content? We require training, we have advanced training, but in terms of what sits in that bucket, this is also something that we could, more nimbly work on, but I'm not quite sure how we do that, not having been there for the beginning or the middle or the end here. Commissioner Roy.
Thank you, Madam Chair. And since you did raise that and it is relevant to social consumption, I did receive an email from Ellen Brown, who is the chair of the subcommittee that I'm the liaison for the research subcommittee. She's a member of the CAB, she's a veteran, and she's also an RVT trainer. And she said, I was watching today's CCC meeting and there was a discussion about updating the RVT program. Is there going to be an opportunity for RVT providers to give feedback? And is there an opportunity to be on a working group that discusses updating the RVT program? So I will share that. I can't share it. I spoke about it publicly, so I can send it to you now.
You can
Yep. So I'm going to forward this and then you can reach out to Ellen, since you two are on the group, to get her.
Commissioner Stebbins.
I appreciate Commissioner Roy, and I'm glad Ellen reached out to us. Obviously, if we make any changes to RVT, it's in regs, so obviously we need to do public comment and public.
But can I ask, but is the content in, it's just the requirement, but the content?
It's a conversation I think we can have with licensing.
Okay.
Licensing currently approves all the RVT trainers at this point. And at the same time, I know we've had a discussion about whether what we require of the basic core curriculum is still appropriate or should be updated. I think it should be updated. I also think.
I don't think there's any disagreement.
I don't think there's any disagreement.
No, I think there's consensus.
But I also think, Chair, to the point you've raised about training folks for compliance, that maybe some of our RVT shifts towards using those as educational compliance sessions, so folks know, again, maybe even using our own investigators to talk about what compliance should look like. I think that'd be a good next step.
And this is also, and also bringing it back to the work that Director Enos is doing, and how we can begin to regularize communications with licensees, but also with, in terms of thinking about what that curriculum might look like and change. So I appreciate that comment. All right. So, Attorney Baker.
Thank you. Just quickly, some of the things that are currently baked into the RVT training that I think helped Commissioner Stebbins in this regard was strategies for de-escalating potentially dangerous situations, procedures for addressing medical or public safety emergencies, and recognizing signs of impairment from alcohol or cannabis use. So there's a number of public health and safety focused things that we have currently baked into the RVT training that you guys will review upon the working group.
Thank you, Commissioner Stebbins.
And thank you, Thank you, Deputy GC, and also the final provision, which is such other areas of training as we may require. So it gives the commission some flexibility at the start, and as we mature and may need to make changes, we have the opportunity to do that.
Thank you. Executive Director Hurt?
Thank you, Madam Chair. And I would just note, we're going to talk a little bit about implementation and probably as well on the 11th, but I think RVT specific to social consumption, a working group to put that together, including feedback from external stakeholders, although as the attorneys have mentioned, a lot of that has already been received, but to work with those folks. RVT is not a one-for-one with tip certification, for example, on the alcohol side, but we will be looking for training, that would be available for people who are directly serving, as opposed to somebody right now who's in a retailer or who's in a manufacturing business. So there will need to be development specifically within the process that we'll lay out for implementation, and a working group that will have commissioner sponsees, as well as be led by our Director of Enforcement Training, Director Enos.
All right, thank you. So I don't know if anybody has any additional comments or questions right now. So we're now getting to the dotting the i's and crossing the t's, but I think we are about 99% there. Attorney Baker, if you.
Thank you, Madam Chair. Yeah, so we will, if we're taking this back up on the 11th, we will try to have a draft back to you in the public as soon as possible. So please look out for that.
Thank you. And just to, again, I don't know if anybody wants to make any additional comments, Commissioner Roy?
Thank you, Madam Chair. I just want to thank Attorney Bruno and DGC Baker and our paralegal and everybody on the legal team and everyone who did the yeoman's work to get us to where we are today. This was a long time in the making. It's a significant milestone. This is the will of the voters. And so there was a lot of thoughtful, mindful deliberation, collaboration. We went on multiple municipal tours. We heard from a lot of folks. So this is the crescendo, if you will, of all of that, and look forward on the 11th to voting on this. And this is a brand new sector and a big milestone that's been eagerly and long awaited and anticipated. Thank you.
And I applaud the work of Commissioner Stebbins, having led this working group for a number of years. And I applaud Commissioner Benedon for, like me, missing out on most of the conversations, but still trying to keep up with the work that our fellow commissioners have done, prior to this. So I thank everybody for that work. So, so with that,
Sorry, Madam Chair, would you like me to kind of review, or would you like the implementation discussion to be more on the 11th?
I think we should do it more on the 11th. I want to just make sure that we don't get ahead of ourselves. I'd like to just make sure we take the final vote. There's nothing that's going to be changed, and then we can talk about the implementation. So I'd prefer doing that at that meeting. Okay, so again, thank you. So is there any new business not anticipated at time of posting? I do not believe so. And the next meeting date is December 11th. Now, again, we have a very robust agenda, but this will be, we will have the final vote, vote on these regulations. We will talk about the rollout, how we're going to be doing that, the different working groups. We now have a little more robust input from our responsible vendor trainers, and we'll see how we can engage them to help us with that, because that's an important part of this. And then there are a number of other smaller items that are up for discussion and votes, but I think we're in a pretty good place here. So again, I want to thank the entire staff and I want to thank our IT people, and I want to thank Nick for teaching me how to make copies of things today. So that's my last shout out after I don't know how many years. So anyway, so with that, Commissioner Benedon, I will entertain a motion to adjourn.
Move to adjourn.
Do I hear a second, Commissioner Stebbins?
Second.
Having been moved and seconded, I'll call the roll. All those in favor say aye.
Aye.
The ayes have it. Thank you.
Thanks, everybody.